Welcome to this edition of Thought to Action, presented by the Herb London Center for Policy Research. I'm Chris Cordani. If you enjoy our content, don't forget to hit that like button. Also, comment, share, and subscribe. To enjoy sneak previews of our videos, exclusive content, and more special programming in the works, join our Patreon page. That's patreon.com/thought-to-action. As a subscriber, you'll also have access to our Ask Us Anything sessions, where we at the London Center answer your questions. You can also follow us on Facebook, Twitter, LinkedIn, and our website, londoncenter.org. There was some serious fallout coming from the Rittenhouse trial on several fronts, and there looks to be more. What we're going to discuss today in a panel situation is self-defense, minimum response, and the rule of law. Perhaps a further look into prosecutors' tricks and what, in this case and many others, amounts to abuses of their power. Media lies and assertions about a man, a minor at the time, before he saw his day in court. A presidential candidate's defaming a man who, and without evidence, we've got to add that, without evidence, calling a minor a white supremacist solely for political gain. Our panel from the London Center will address these issues on Thought to Action. London Center for Policy Research President, Lieutenant Colonel retired Tony Schaefer, London Center Board of Directors member Bennett McFadder, Senior Fellow Lieutenant Colonel British Army retired Tim Wilson, Distinguished Fellow Brian Griffin, and Distinguished Fellow Navy Captain retired Pete O'Brien. Let's jump into this. Self-defense was the ruling. We discussed minimum response briefly in our last panel, but let's talk about all of that along with the rule of law.
The rule of law, and I think we've covered this in a number of our discussions, relates directly to the Constitution. The Second Amendment is very clear on shall not be infringed. What I interpret that to mean is someone who's had to use firearms my entire professional life, both in a military and intelligence capacity, as well as a private citizen, is that you should maintain the ability to defend yourself against all threats at any time. And this is one of the things which I think the rule of law showed through in this case. And I find it interesting and fascinating that so many folks on the left, who were, I think, fed by the mainstream media, were never provided the fundamental facts of the situation, of the Rittenhouse response to the threat that should have been linked from day one to the Constitution and the law. So this is where I think there's been a three-way travesty. First, the prosecutor should have framed the prosecution within the context of what is permissible relating to an individual's right. They didn't start from that point. They started from the point of how can we remove the fundamental right of an individual to have the defense. They said it over and over. The right of self-defense was attacked relentlessly. Oh, we only had a pistol and you had a rifle. What? So that framing in court indicated that the charging documents were meant to undermine the individual right. So this was not just about Rittenhouse. This was about the right itself. So that's number one. Number two, when you examine the facts, when you examine the night of the shooting, there's ample videos which show what Rittenhouse did to defend himself. This is, one of my friends was actually there as a reporter monitoring this. He was actually cited in the case as someone who was endangered, supposedly, by Rittenhouse's actions. So this is something that people observed directly. You could observe. There was no ability to not see if you actually examine what was going on. And what was noticeable is that the media misportrayed it or excluded it from their presentation of facts. And third, and this is what I think is something else we want to talk about, is the fact that this became an emotional issue for the left, where this act of self-defense was considered white supremacist. So I'm always fascinated that anybody who decides that they're going to apply correctly their rights within the right context and within the right circumstance instantly becomes the enemy of the left because it does not meet the left's narrative. To include in this case people lying and saying that he shot 3 black men. So this is where the rule of law should apply going back the other way, to go after all of these obvious judicial and prosecutorial issues, as well as the political issues. This is where the law and politics overlap, where obviously the jury decided Kyle Rittenhouse acted appropriately. That judgment was sustained. Now, in my judgment, there should be a counteroffensive to go after the prosecutor. But the judge should go after the prosecutor for overcharging and misconduct. Rittenhouse should do what he can to push back and correct the record, to include suing media outlets who have misportrayed him, and frankly, going after some of the politicians. Joe Biden used the white supremacist rhetoric in his campaign, in his 2020 campaign, several times. So this is not appropriate, especially when you put it all in context of the fact that this was a minor. He was 17 at the time. So I think there's ample evidence that the rule of law is something that was not observed by the left. The left has done everything they can to undermine that, and they've used emotional, completely factually unsupportable arguments to do it. So that's my opening posit on the issue of rule of law. So there you go.
If I can jump in then and immediately say that the background to all of this was really important for the way that this entire country operates. And as you rightly say, Tony, the rule of law. We hold these truths self-evident, that all men are created equal, except that the left, we had months before Waukesha, months and months, many months of left-wing riots going on, and that presumption of innocence was applied vigorously in their defense on the rare occasions when they were arrested and charged. Some of them have still been found guilty, but very, very few. I think the whole country looked at what went on that night in Waukesha. There was enough social media video on the night of the event, live, and then replayed and replayed and replayed, that although video can give false impressions, when it comes live and natural, people are able to pick up very much for themselves. And the court of public opinion, I feel quite strongly, swung in favor of Rittenhouse and against the incompetent prosecutor who obviously doesn't even know the basic rules of gun safety.
I'll just jump in here. Tim, you said Waukesha. I know you meant Kenosha, but I think you're bringing up a very important point about Waukesha, because we're no longer using the courtroom as the ultimate place to be the arbiter of justice and what is right and wrong. It's the media. And there's a huge problem with the distinction between the way that the media has reacted to the facts surrounding the Rittenhouse scenario and the facts surrounding the Waukesha scenario. And it's evident that the media finds one of these incidents to align with their narrative and one of them not to, and they're changing the way that they talk about it and cover it and report it. And not only is that damaging to the credibility of the media, that's damaging to back to our rule of law here, right? Because it is important that everyone is presumed innocent until proven guilty. Rittenhouse by the media was presumed guilty and forced to defend his innocence. And whether or not you agree with the facts of his case or his decisions or what he did going to Kenosha, the rule of law protects everybody. And if we scrap the rule of law, then as soon as you're on the wrong side of it, you're going to change your opinion and be back in favor of having that very important standpoint. So the way that the media interacted in this case was really alarming, especially the journalist who was following the jurors home and intimidating them, Also, that the media was building up a lot of intimidation on the jurors to make the politically salient decision instead of what might be the actual just and fact-based decision. If that happens, if it's no longer evidence that we're using to make decisions in courtrooms about, but popular opinion, then we really have forsaken this critically important rule of law concept that our country was founded upon.
I want to add, Brian, that you bring up the journalist, the camera guy who tried to film or take pictures of the jurors in the Rittenhouse trial. This is not just some rogue guy. He was a contractor. Yes, he was hired by by MSNBC. But the fact is, this was sanctioned by the producer and most likely the people who are higher up. This is the same channel that's been kind of lying about, one of the same channels, I'll say, that's been lying about Rittenhouse from the start, trying to push that this whole thing was about white supremacy, trying to push that Kyle Rittenhouse was not supposed to be carrying a gun, but and lied about, of course, the law when it came to that. Your CNNs, your major network news, your MSNBCs, that kind of behavior that you discussed is sanctioned by the leadership and ownership. That's something we have to contend with as well.
I want to jump in here and say, too, with respect to the media, there's statistics out there that the major media groups are owned by a small handful of corporations. It used to be that the newspaper or the news on television was accountable to their viewers, that if they said things that were offensive to their viewers or to their advertisers, there would be a market-based penalty to that. But now, when you have media owned by very large corporations, which media outlets are a small fraction of their revenue, they can well afford to disregard all of that. They can well afford to push ideological agendas, despite what the majority believe. When you have either the President of the United States or anybody, not president at the time, but a candidate, Biden, who made a judgment without any evidence, or without enough evidence, maybe a future court will decide, against the private citizen. Now, private citizen, somebody different than, say, Tony, right, who's achieved a different status, the famous status where you have to prove actual malice. When you have a private citizen and you have somebody with a really big microphone out there, whether it's a news anchor or whether it's a presidential candidate, who are saying false things, that's a tort. That's a tort. And there's a remedy in the law to go after that. And to the extent that a lot of these things are let go, where people do not exercise their remedy and file a lawsuit with lots and lots of zeros attached to exercise that remedy, it allows and almost encourages the continued bad behavior.
I agree with everything that's been said here. And so I don't want to beat a dead horse here, but I would like to add just a couple of points. If you go back and look in the history of jurisprudence, back quite a ways, centuries and centuries, before this country was even founded, the idea of forcing the state to prove guilt rather, is well established. People might want to change the world, but there are some concepts you really don't want to change. The founding fathers were very clear on this. If you go back and take a look at the documents leading up to the Constitution, and by the way, one of the fellows involved in all this, John Adams, was the fellow who defended the British at the Boston Massacre and acquitted six of the 8 soldiers and the four civilians who were involved. They were acquitted based upon John Adams' argument. So there is a long tradition of forcing the court to prove guilt. I would add, though, that if you look at the Constitution, there is no place in the Constitution in which at any point they discuss your loss of a right based upon some action of yours. You don't lose rights. They're very clear about it. They're very clear about the idea that the rights if you read the surrounding documents, the surrounding writings, the Federalist Papers, etc., they're very clear that rights precede government and that they have to. And whatever nonsense might be taught in some poli-sci course at college these days, the fact of the matter is that rights have to precede the government or they mean nothing. And the founding fathers were very clear in the idea is you simply don't lose a right. You can't lose a right. It's yours. And so this idea that somehow this was a different case or we need to change the way this is done, those are Looney Tune kind of comments when you go and look at what that really means to a society and how we have taken centuries and centuries and centuries, millennia to get to this point, and we do not want to unravel it.
I agree with that, Pete. If I can make a comment on that, we are, the Rittenhouse case is a symptom of an ideological struggle that's been going on for decades, and I think in some sense we are struggling as a nation to determine or possibly redetermine the source of law. And when I say law, I mean the God-given rights. That there is a creator, that the Constitution was established to secure those rights, which our founders determined to be self-evident, axiomatic. They are the rights. They exist. They existed before the nation. They existed before the Constitution. If you look around the world at any of the other countries, socialism, communism, the government becomes God. The government replaces God. The government says, we will tell you what your rights are because you're essentially a subject, right? You're a subject rather than a free, independent citizen with individual liberties. And, when you look at that, in the Constitution, we talked a lot about the Second Amendment, and obviously, right, an AR-15 was involved, so we talked about the Second Amendment. But there's another fundamental premise here, and that is the right to self-defense and where that right actually comes from. So if you have the right, capital R, to life, and that is, before, right, antecedent to is before any of, even the Constitution itself. And what does that really mean? You need to defend yourself. You have the right to defend yourself or defend your loved ones in a reasonable way. And when you look at things, I hope that in the discussion, I won't go on too long here, but I'd love to get into some of the details that the prosecution presented, how they slowed down the video itself, really these due process issues, what I see as due process issues in the manner in which the trial was actually conducted.
Bennett, you bring up a great point, and this is where I want to go as well. We saw a lot of what was happening with the Rittenhouse trial. You got to see a lot of it streamed. The highlights were out there. And make no mistake about it, these prosecutors pretty much thought they had the media in its back pocket. At least that's what it seemed like. I'm making an assertion. So that's what's happening right now. It's what I saw. It seemed like the prosecutors thought they were free to do whatever they want because popular opinion, again, in their mind, popular opinion, thanks to it was all over Twitter and other social media and maybe your CNNs, et cetera, the idea was they thought, hey, we could do anything we want and people will still despise Kyle Rittenhouse enough and the jury will despise him enough that we can ensure a guilty verdict on at least a few of the counts as long as we kind of skew a few things or kind of make him look worse. Bennett, like you pointed out, the video. What I saw was prosecutorial abuse. At least that's what it looked like from here. These guys knew they had, or thought they had, a sort of home field advantage, if you will. And they did what they could to kind of to sway or use emotional arguments to push out or squeeze out a guilty verdict, despite the rule of law.
It was evident in the charges that were brought against Rittenhouse in the first place that the prosecution was stretching. They knew they had a problem from the beginning, and basically what it looked like to me was that it was a political prosecution, and that was clear as well from the time of the event with the media, some of the large media outlets immediately accusing Rittenhouse of murder caught on camera. Self-defense doesn't occur to people like that. It just does not matter in their opinion. But the prosecution overstretching from the very beginning with the charging led to all sorts of things, including charges that the judge then later dropped because they weren't relevant. They had not actually looked carefully at the law in the same way as those prosecutors, obviously, the one in particular, the assistant prosecutor, who didn't know what he was doing in handling a gun and pointed a weapon with his finger on the trigger at the jury. When you're that incompetent, you have a problem. When the charges are political, you have a problem. The jury saw that. I think most of the public saw that. I think those of us that followed it on media saw that from the very beginning, because I think the reasonable general public looks at these things and says the guy was defending his own life. That cannot be wrong.
The prosecutions are notorious for overstretching with their charges. As a Floridian, we all remember the Casey Anthony trial, where I think the same issue happened. To me, the biggest issue that the biggest problem that the prosecution incurred is when they commented on Rittenhouse's silence shortly after arrest.
Yeah.
That, to me, was the closest thing to being a real due process or rule of law violating issue, because you're never supposed to comment on the silence of the accused. Everybody is allowed to remain silent. It's a constitutional right to be able to remain silent and not speak out against oneself. The judge rightly corrected him. By the way, I think the judge did a great job in this case. But all of these individuals involved in the trial, the jury, the prosecution, and even to an extent the judge, faced enormous public pressure, which might have caused them to make different decisions or do different things than they would have done in what the courtroom is designed to be, which is a completely neutral space, kind of exempt from the political pressures of the world to get to the bottom of a factual matter. So to the extent that the media is responsible for undue influence from the outside, that's really problematic. And by the way, I think we're going to see that happen in every one of the cases that come along like this, where the media is going to make a decision about something and everybody in the courtroom is going to feel compelled to either accept the media's decision or to act in some way based on what they believe public opinion wants them to do. But here's the thing that I think is maybe should be said from the beginning. If you're on the other side of this issue and you're concerned about white supremacy, well, myself and everybody on this call detests white supremacy. And by the way, we detest every type of supremacy. But the first thing that would have to go in this country for supremacy to take root and succeed is the rule of law and due process. Because the rule of law and due process actually prevent any type of racial or other shallow, superficial supremacy from infecting what's supposed to be neutral, the blind justice courtroom. So even the critics should be celebrating the way that the judge upheld rule of law and due process in this case, and should be taking issue with the way that the rule of law and due process were harmed by some actions of the prosecution and the media's influence.
The idea of using race, economic status, or any other discriminator to remove accountability is something no one I know accepts. No one. I think we all can agree that the law, the Constitution, must be blind to economic circumstance, racial background, or anything, which is what I find ironic about the fact that I've been called over the last 24 hours a white supremacist probably a dozen times. And it's not factually correct, something that I would never espouse. And this is what's incredibly divisive about the left. While we call for a blind justice, the justice should be applied completely without regard to a person's race, creed, color, or background. And yet they are the ones who constantly accuse others of what they're doing. It's pure projection. And I think the Rittenhouse events, the trial, the coverage, the outcome, all is a clear microcosm of how completely bereft of standards the left is on this. And it's a very dangerous thing because people, if they're not paying attention, could actually potentially believe what they're saying. It's a very dangerous thing.
Could I just jump in again, a short point on that? You know that it's a really strong sign that it's some sort of political persecution when the prosecution is effectively, as they did with Rittenhouse and the point that Brian mentioned about staying silent, when they're saying you need to prove your innocence, not we have to prove your guilt. As soon as they start down that line, it is a political prosecution.
Well, and if I can add to that, there are structural problems, and a lot of people have seen it not only in this trial, but in many other trials, structural problems where, for instance, the prosecution will blatantly violate the rules of criminal procedure.
Yep.
But blatantly violate the rules. One of the ways that they violate the rules is that the prosecutor will make some statement as if it's a fact, but he won't cite anything. He won't cite a witness. He won't cite any evidence that he has. He makes a statement and it just sort of hangs out there. Where there's a rule that says, and this is part of protecting due process, right? There's a rule that says the prosecutor can be a prosecutor, or that same person could be a witness, but they can't be both. So they, when they go out and make statements, Rittenhouse did this, Rittenhouse did that, and those statements are not challenged. And there was many times when his defense attorneys did not challenge those. That may have been strategic. There may have been reasons for that, but there is little accountability for the prosecutors that do things like that actually violate due process. There's really no accountability back on the prosecutors themselves. They don't lose their veil of protection and sovereignty by the state because they violated their oath or they violated the rules which they are sworn to uphold, and they know those rules. So they violate these things with impunity, and this is one of the ways that when behavior is not checked with accountability, it continues. So when that kind of behavior continues, I mean, there are cases that I've read about, Supreme Court cases that question whether or not the court retains jurisdiction after there is a fraud upon the court. A prosecutor coming in there as an officer of the court and saying something, violating the rules, saying something he has no evidence to back up, is a form of fraud upon the court. Tell you another form of fraud upon the court is, the video in this case that they did, but generally noncompliance with Brady, right? And the subsequent other, rules that say that you have to turn over the information. In this case, and speaking as a tech guy, the video. So the video was a much smaller video, and we all saw that it was grainy. One of the things that I didn't see, and I don't know if an analysis was performed on this, but I'd certainly love to know the answer, is whether or not frames were dropped. When you go in there with a video that's, whatever it was, 60 frames per second, and you're going through there and looking at what position was the gun, where was the pursuer, how fast was his rate of closing, how far away was he? If you're able to drop out frames to say, well, this is 30 frames per second plus reduced resolution, or this is 20 frames per second plus reduced resolution, you miss the literal frames where, you could see if the gun was in a different position, if the individual was in a different position. But the fact of the matter is, the prosecution in this case, as with many cases, knew darn well that they didn't turn over the original video upon which they were relying and they were using for their own case. They didn't turn over. It was completely unfair. It was a form of fraud upon the court. Yet there's nothing that's actually done to the prosecutor. So escaping the bear trap, and the prosecution losing a case is has not been. If you look at the prosecutions and what prosecutors typically do in a lot of the cases around the country, especially true of federal prosecutors, and this wasn't a federal prosecution, but especially true of federal prosecutors that are notorious for this, they get away with doing whatever they want.
That was the trick. The idea was to send the defense the lower resolution video so they couldn't really devise a plan to come back at it or say, hey, this is what the video is showing, where the prosecution gets to show off the higher resolution video and say, well, we're not technically savvy. We didn't know that they had the wrong resolution. It is kind of plausible, I suppose. But do you really believe that?
But in fact, as Bennett points out, it is a de facto violation of the principle of disclosure, which is found in virtually every court jurisdiction in the Western world, and it's horrible that it happens. It raises the simple issue of how do you police this? How do you fix this? And not just in this particular case, but we've all seen frivolous lawsuits left, right, and center, ridiculous decisions made in courts, ridiculous decisions made by various lawyers, and it gets back to a couple of simple issues here that need to be addressed. One is that the Bar Association in each of the states of the Union need to be brought up short. They need to be made to do their original job, and the legislatures also need to do their job and tighten up the law. And aside, there's a whole host of issues that need to be tightened up. But when you have a judge giving a 30-plus page instruction to a jury and also commenting that he's not really sure about some of the issues, that it's not clear, that's bad law. That's so there is a community of people who write laws and practice law. The bar associations of the states, the American Bar Association, the national organization, needs to be tightened up, and the legislatures in the states need to be tightened up as well. We need to address this. This is a real problem, because what it does is, in many cases, it would seem to make justice in the philosophical sense more difficult to achieve. And if you go back to the preamble of the Constitution, it gives a vision statement. Form a more perfect union and establish justice. That's what we're trying to do here, and organizations like the Bar Association should be helping, not hurting them.
I'll add to your to-do list, Pete, with one more element, and that is public education on some of these concepts. Some of us on this call are lawyers, and we recognize these issues because they were taught to us at law school. But every one of these issues is a fundamental, critically important element of a body of rights that every American citizen holds. And when the media wants to just kind of throw these out so that they get their verdict in the trial, they're harming everybody on every side of this issue. And I think that everybody needs to know what these issues really, what the consequences are for throwing these issues out, for them to be able to speak up and defend them. So, for example, with this evidentiary issue, so the state will always have more resources and more means to be able to come up with and produce evidence than any given defendant. That's why the precedent has been set in our court system that any evidence that the state has must be turned over to the defense. You can't surprise people or use the disproportionate resources of the government to be able to make a better case. I think when that's understood, everybody says, that makes a lot of sense. I want to defend that principle in this situation, because it keeps everybody safer, everybody freer. It keeps everybody from having to kind of fight, the government and all of their resources, even when they're innocent. But people might not recognize what's going on here, and it's hard. It's very hard to, I think, without a legal background, watch this proceeding on TV, listen to the legal experts talk about these issues, and maybe not have the same reverence or desire to protect the rule of law when these things aren't really understood. So I wish that we had more public education on these issues. I'm glad that this trial brought some of these issues up and that we're talking about them. I would say, instead of critical race theory being the obsession of teachers in every classroom. I wish it was something more like critical legal theory or critical rights theory. What is this precious body of rights that you have as an American citizen? How do these rights protect everybody, no matter what political side you're on or what your skin color is or whatever division we might have? How do these rights protect everybody, and why are they worth defending in these situations? And I just bottom line here, for the media to throw these out or to ignore them or to downplay them so that they can get their desired outcome in this case, it really is harmful to everybody's ability to exercise these rights, have them, and protect them.
A lot of you come from a legal background. I come from a media background. We used to use words like allegedly or accused of when it came to describing cases like this. Nowadays, we're having media members talk about people like they're guilty a year before the trial or not guilty, depending on where the narrative flows. And they have to stand themselves corrected. So they push a little retraction and it goes down the memory hole. That's another problem we have to deal with as well. And then it comes to these politicians who are inserting themselves into these investigations. If you remember, President Obama inserted himself into the Zimmerman Trayvon Martin investigation. You have these politicians yammering about a case they barely know anything about because some of the information's suppressed on social media anyway. They get what their advisors tell them. And even now we have a sitting president who injected himself into the Rittenhouse trial, both as a candidate and a president, accusing the kid of being a white supremacist. The man stopped short of saying, if I had another son, he'd look like Anthony Huber. These are problems we have to address, and people like Kyle Rittenhouse are A, going to have trouble getting a fair trial in the future, and B, their names have been dragged through the mud as guilty in the eyes of so many people in the court of public opinion and the Twitter blue check marks that he's going to have trouble. And Tim, you presented this off the air beforehand. He's going to have trouble going to Arizona State University.
To that point, speaking as a Twitter blue check mark, first off, it's overrated. And secondly, what you're saying is absolutely true. Twitter's not a real place. But let me say that it does have an artificial influence over events going on around the world in the United States. So someone who's engaged in Twitter fights constantly, just over the last 24 hours, there's a mob out there who will take one piece of information and they'll go after you. And so in this case, the Rittenhouse issues were manipulated, and I feel sorry for Kyle, speaking as someone who has an experience in this. And the facts matter not to those who have decided that they are the morally superior blue checks, and whatever they say will go. And so this is one of those areas where I applaud free speech, but that free speech can be very dangerous in a circumstance like this, because people who don't understand that Twitter's not a real place actually may take action based on some of the artificial and often obtusely incorrect opinions of the blue checks. So I agree with what Chris is saying here. It's very dangerous.
If I could jump in too, I just want to go back, and I agree with everything again what my colleagues are saying here, but particularly what Brian just said, the need for what used to be called civics in American classrooms and basic American history. It wasn't long ago, one generation, where you could go into the average public school and you would hear at some point or through the year someone quote the great line, "It's better than 100 guilty men go free than one innocent man go to prison." Ben Franklin, although others said it too, Voltaire, etc. But the idea of how the law is supposed to work and the protecting of the innocent and the basics of rights and what this wonderful experiment we're engaged in called the United States, that used to be taught. That needs to be taught.
Like government, some people have described government as a fiction. It is a fiction. It's a form of fiction. It's artificial. Government would not exist but for mankind. We have put these governments together for what? In our government, in the United States, and in the Bill of Rights and in the Constitution, it is very, very clear that we put that there to secure individual liberties, and for which each and every individual citizen, not collectively, but each and every individual citizen is an express designated beneficiary. It's a beneficiary of the Constitution. Okay, so if you look at this sort of structure that we have set up in the courts, the judge is supposed to be, and I agree with Brian. I think the judge in this case did a really good job, but the judge is supposed to be essentially a trustee of the law. The judge is supposed to know more about the law than anybody else in the case there. The prosecutor has the prosecutorial role, right? The adversarial role, but everybody is supposed to follow the rules. And this is where, when people go out and they make these accusations without a basis, without firsthand knowledge, without, any reasonable degree of actual evidence, they do disrespect and demean our form of law in its entirety. They disrespect everybody's right to a fair trial. They disrespect everybody's right to due process. So when you have due process in this country, where essentially our system of laws is, to me, I distill it down to, if you're accused of something, oh yeah, prove it. Okay, prove it in a court of law with the rules, with admissible evidence. And if you can't prove it, then, you've just committed a tort. And we'll know at the end of this process what it is. But when you have people that can commit one tort after another, when they can put in one fraudulent claim after another, like many prosecutors do, and I don't mean this to be, a big hit on prosecutors, but prosecutors have a critical and important role of, not only winning at all costs. They shouldn't be winning at all costs. They should be looking for justice. And where they go in and they actually violate the rule of law, that just clearly shows that they're not seeking justice.
Maybe a good final comment on this matter is, for further reading to help visualize what the world would look like without rule of law or due process, read Gulag Archipelago, which was basically a classic work of nonfiction about Soviet Russia. And here, the government was able to use a sham court system to arrest people. They presumed them guilty and put them away for having political dissent, the wrong opinion, the wrong skin color, anything that the government didn't like. And due process and rule of law could not exist in that scenario because those things protect people. So I would just, for further reading, to help visualize what we're looking at. And China now, exactly. People disappear because of offenses, and they're presumed guilty, and maybe never given the ability to presume their innocence. So that's our mission here at London Center. We don't want our country to ever get close to that point. So we're going to keep talking about these issues and making sure that they are rightfully defended.
You can also refer to the Accountability Project on our website, londoncenter.org. In fact, when I started here, the London Center was involved in and looking into the case of Dr. Atif Malik, who was also a victim of prosecutorial abuse. You can read more about his story on our website, londoncenter.org.
This has to be a wake-up call for any American, left or right, who understands the importance of the Second Amendment and the right of self-defense. One of the things that's notable about the left is that many folks who were formerly of the left, I would consider them traditional liberals, have recognized that the progressive left and the liberal left are not the same thing anymore. Tim Pool comes to mind. Tim references himself as a left of center guy. I respect him, but he's a big Second Amendment advocate. And one of the notable things is that where you see progressively controlled cities with the most restrictive gun laws and prohibitions in the nation, you see the highest level of murder, crime, and mayhem. So I think it's something that we are obligated as a policy think tank to try to educate the public, as noted by several of our fellows and board members, and at the same time recognize that those on the left who have been, I'll just say it, lied to by their own side regarding their right of self-defense. And I think this is something that we should engage in. As you all know, we've asked some folks to join us. Kimberly Klasick, who is one of our senior fellows now from Baltimore, from what I consider a battle zone of the East Coast. And that battle zone is not because of anything other than the complete denial of the individual right of self-defense. And when you take away that right, you make people victims, and those victims are indeed targeted by those who are armed, by those who will not follow the law and will seek to gain advantage by using those weapons to harm others in the course of their economic enrichment, robbery, mayhem, and other things. So I'd like everyone to join us in this effort to educate. It's not simply about the left or right. It's about the right or wrong of the individual right of self-defense. And I'd like to believe people will recognize that from watching our interactions today.
This was a triumph of the jury trial system in which 12 good citizens and true unanimously on 5 different counts found Kyle Rittenhouse not guilty. Thank you to the judge, thank you to the jury, thank you to the whole system, including the prosecutors, for actually using the system properly to come to what is inarguably now, because it's been through a jury trial, a correct, not guilty verdict.
Thank you for being with us for this edition of Thought to Action, presented by the Herb London Center for Policy Research. Please remember to hit that like button. Feel free to comment on our discussion. We appreciate your thoughts. If you haven't already, please subscribe to our Thought to Action channel and pound that big red bell for updates on future shows. Find out more about the London Center on our website, londoncenter.org. If you'd like to help us continue to create discussions and programming like this, please join us on our Patreon page, patreon.com/thought-to-action. You can enjoy sneak previews, special exclusive content, and our Ask Us Anything sessions. Also, you can help us greatly by sharing this video with your friends, colleagues, and social networks. For our panel at the Herb London Center for Policy Research, I'm Chris Cordani. Thank you, stay informed, and make your day a great one.